Hello, everyone. My name is Apar Gupta. I'm the founder director of the Internet Freedom Foundation, and I'm here to present our first quarterly membership call of 2026. Thank you for everyone who's joining us on the live stream. And please mention all your comments that can be put in the YouTube comments box. We will show it on the stream, and we'll try to also address them. We have themed this call under the title Another One Fights the Dust, which may seem comical, but is not really. Because every quarter, when we sit down to take stock of the list of things that have quietly eroded, quietly normalized, quietly made invisible threats to our digital rights, that list gets longer. It may be a new law, a new surveillance system, a new takedown rule that doesn't quite cover the harm that it was supposed to, but results in censorship. All of this can be basically dust which settles on our democracy. And sometimes it's very gently, it's a thin layer which we don't notice, but it is settling over a period of time. So, this is your quarterly membership call for January to March 2026. And what I want to do today is to tell you honestly that without a sense of false urgency or any form of exaggeration, what we did, what we were up against, where we failed, and where we are succeeding and putting our efforts. So, if we can come to the second slide, the movement which we are in right now, if we can come to the second slide. Hello, if we can, yeah. So, sorry for that. So, let me start with the moment which we are in and just a short synopsis of where we find ourselves. So, we all know that digital technologies are today not mere tools of convenience. They are quite often instruments of governance, of control, of just a daily form of existence for many people. And here, AI systems quite often are making decisions about who gets welfare, who gets flagged in a policing system. And there's also been a growth of surveillance infrastructure, which keeps expanding under the language of safety, but sometimes does not even serve the very people who are harmed. And regulation, quite often, even when it tends to arrive, it's not a shield. It's quite often a lever for state control. And this isn't just in abstract. Through the course of this call, my colleagues will show that we've seen an expansion of facial recognition technologies, citizen profiling, and the use of the Digital Data Protection Act, which is a law to protect your privacy, but has raised many concerns for transparency and press freedom. So the question I keep returning to is simple and difficult, that in a period like this, when there we see these kind of environmental threats which always surround us, how does a small independent publicly funded organization like us, like IFF, hold the line? Can there be hope, if not optimism? And how can we just continue doing the work which we do? And I do think we can do it, which is shown through January, February, March. It's not like it's not without setbacks, but we've done it. And we can be honest about what it costs. So if we can turn to the next slide, which is slide 3, and we can explain a little bit about IFF's work as well. So for us, survival means not giving up, and that means three things. First, to protect fundamental rights, the rights that are already in the Constitution, but quite often are not enforceable or be hollowed out by executive action or by technological system. Second, to challenge systemic inequality, because digital systems don't affect everyone equally. They hit those hardest, which are already marginalized, already surveilled, already excluded. And also to co-build a democratic civil society where we possibly support other democratic actors such as journalists, cartoonists, filmmakers, many people who expand the range of diversity of sources. And survival for us here doesn't mean retreating into a safe fundamental topics. It quite often means staying in the fight on surveillance, on censorship, dealing with the harder questions, which in the current political environment may bring discomfort and even may challenge funding. And uh, quick word, a quick word on what IFF actually is, and for those joining us for the first time, we operate at the intersection of law, policy, and public awareness. We are a small team, and we try to do as much as we can, but we have a limited capacity. We take on constitutional litigation that can set precedents. We produce policy research and do advocacy around policy as well. And we run civic literacy programs that sometimes reach millions of people through social media collaborations and public education. This is primarily done through our digital channels. This work is resource intensive. It relies on a very skilled, talented team, a passionate team, which will present its work to you through this call. If you can come to the next slide, and just wanted to quickly come to, I think we can skip this one. We can come to the next one. Yeah. And here, basically, you may see some screenshots from our blog as well, where on our website and through our social media, the kind of issues we are working on in strategic litigation, in policy advocacy, or civic literacy. So these are the kind of guides we are making, or the strategic litigation we are doing. If you can come to the next slide, which is a quarter at a glance. So from January, we've tried to just give you a snapshot of the work we have done. We've published about 20 policy analysis and explainers, which is covered from the DPDP draft rules to Delhi's safe city surveillance expansion to AI generated um, deepfakes, which quite often really harm and injure women. We've initiated three new constitutional challenges, including the DPDP Act in the Supreme Court, and one on coercive biometric collection under the Criminal Procedure Identification Act in the Delhi High Court. We've provided legal support at least to 12 individual creators and journalists who have been censored on uh, online platforms, and they face legal threats or state action. It's basically resulted in takedowns or blocking of the accounts itself sometimes. And our civic literacy work has averaged over 1 million impressions, and this is just Instagram per month. And this number reflects not just reach, but genuine public appetite for this kind of information. It's been done by a skilled team and contractors who have worked on it, which includes infographics, comics, and reels. And we've done this in a way in which we tie it back to the kind of work which we do. So it's not freestanding from the policy work or the litigation which is done. So this quarter reflects both a sense of depth and urgency. We've tried that, we've attempted that, we've failed sometimes, but I hope we've also succeeded. And now I want my colleagues to take you through the specifics, the kind of work they have done, and I'll return a little later, possibly to also provide you a financial picture, disclose finances to you, how much money came in, how did we spend it, and where's the shortfall. So thank you so much for joining us. Over to you, back to you, guys.
Hi all. So Naman, Avanti, and I will be taking you through the three sets of constitutional litigation that we've been up to in the past quarter. The first one that I will be covering is the constitutional challenge to the Digital Data Protection Act, DPDP for short. Now, the DPDP Act came into uh, play because a nine-judge bench in the Puttaswamy versus Union of India case not only recognized the right to privacy as a fundamental right, but it also said that any future legislation that defines the contours of the right to privacy will have to be in accordance with the principles laid down in that judgment. Now, the principles laid down in the judgment broadly are that a right to privacy legislation must be in accordance with the principles of data minimization, purpose limitation, and any encroachment on the right to privacy should be on a basis that is proportional to the social need which is thought to be addressed. Now, 5 writ petitioners have approached the Supreme Court as of now, challenging the DPDP Act. IFF has supported the Reporters Collective and Nitin Sethi to file their writ challenging the DPDP Act. The scope of these writ petitions are slightly different from one another, but I will cover the grounds on which we have went to the Supreme Court. The first ground is that Section 44(3) of the DPDP Act amends Section 81J of the Right to Information Act, earlier Section 81J of the Right to Information Act exempted information that is personal information in so long as it is unrelated to public interest. The amendment carried out by the DPDP Act uh, limits the scope of that, expands the scope of that exemption by saying that all personal information, irrespective of its relation to public interest, will have to be exempted from the right to information. So you will not get access to any records about corrupt government officials or about denial of welfare benefits to people through the Right to Information Act anymore. The second ground on which we went on a constitutional challenge is the fact that the DP Act has no exemption for processing personal data for public purposes or for journalistic purposes. And this is important because it has very onerous obligations on data fiduciaries, but it does not limit the extent of its applicability to, say, journalists or civil society members. The third ground on which we did the constitutional challenge was on the Data Protection Board, which lacks independence and impartiality because its appointment process is closely tied to the central government. There's another element to this, which is that journalistic efforts may be limited by the rulings of the Data Protection Board itself. The fourth element is that Section 36 of the DPDP Act, read with Rule 23 of the DPDP rules, give broad powers to the central government to require provision of data from the Data Protection Board, any intermediary, any data fiduciary, and it's a compulsive framework for provision of information to the central government and state governments. So this is obviously prejudicial to public purpose and journalistic purposes because a lot of information comes into the hands of civil society members and journalists alike that is confidential and nobody wants that to be further given to the government. And therefore, Section 36 is the constitutionality of Section 36 is being challenged. Some of the practical effects are obvious, which is that this legislation is onerous upon civil society members and the journalistic profession because it puts the same amount of obligations as it puts on corporate bodies. And then the second leg of this is that the DPDP Act requires a lot of information from uh, citizens, but it does not give enough information through the RTI Act to citizens about corrupt officials and denial of welfare benefits. On 16th February, when the writ was listed, notice was issued on this writ. And then on 23rd March, the Supreme Court asked the union to file its affidavit. Issues will be framed thereafter for hearing and adjudication in the matter. And we will keep you posted on any updates to this hearing. And I think after this, Naman will come up about explaining on the right to be forgotten case.
Hi Indu, thank you so much for giving us an intro on Digital Data Protection Act challenge. And as you guys must have heard, Indu discussed Puttaswamy judgment. Now in 2017, when Puttaswamy judgment came, it was a 1,000-pager judgment where Supreme Court discussed a lot of notions on privacy and the contours of it. One of them notion was on a right to be forgotten, and today I will briefly talk about what this right to be forgotten, or I will in short going to say RTBF, means in the context of India, and why the Supreme Court and other high courts are currently examining it. So the right to be forgotten is a notion that a person should be able to erase or limit access to personal information online, especially when the information as per that person is outdated, irrelevant, or allegedly causing any harm to them. So in India, this concept allegedly flows from the right to privacy under Article 21, recognized in the Puttaswamy judgment. So Justice Call discussed this a bit in his opinion while discussing right to privacy and how European Union is dealing with this notion. Even though it was discussed in detail in Puttaswamy 1, but India is yet to codify a right to be forgotten, and its foundation slash origin, ingredients, and applications do not emerge clearly from any central or state statute or any judicial precedent. Furthermore, I believe that things get complicated when RTBF applied to judicial records because court judgments are public documents as per Section 74 of Evidence Act, and they are necessary for open justice and transparency, as we seen in Nipun Saxena judgment. Now the issue reached the Supreme Court through cases involving platforms like Indian Qanun. For example, in one of the cases, the Madras High Court ordered the removal of a judgment from a legal database like Indian Qanun because the person had been acquitted and claimed reputational harm. This raised a fundamental question: can individuals demand the removal of court judgments from public access? Uh, there are some there are several unresolved issues like this. For example, does RTBF mean redacting names, de-indexing from search engines, or complete deletion? What is going to be the legal test to apply right to be forgotten? Uh, Furthermore, how are we going to balance privacy with free speech and public access to information? In my opinion, the crisis become wider and huge when different high courts have started taking conflicting positions from 2017 to here. Some have allowed limited relief like masking identities, while others have rejected right to be forgotten claims entirely due to lack of statutory backing. For example, Internet Freedom Foundation in Kerala High Court fought one such case known as Vaisak KG, where Kerala High Court said there is no right to be forgotten and we need contours and we need to codify it first to even define it. Uh, Certainly, after the Madras High Court judgment, Indian Internet Freedom Foundation moved for Indian Qanun before the Supreme Court, and again against these conflicting positions. And recently, the Supreme Court intervened and stayed orders and directed removal of judicial records and news reports. The order emphasized that such blanket erasure raise serious concerns for open justice and press freedom. Now, I can understand that you all might be wondering that Internet Freedom Foundation is a pro-privacy, and so why are we fighting against right to be forgotten? We are not fundamentally against the idea of right to be forgotten as inherently flawed, and I believe that individuals must have autonomy over their personal data. However, this cannot translate into an unqualified freedom to erase one's past without careful assessment of its consequences. Corporations and many people who are in economic power must remain subject to sustained public scrutiny, even if an individual is ultimately acquitted or escapes liability. That cannot justify wholesale deletion of past reportage. Uh, we believe history cannot be rewritten to suit reputational conveniences. Thank you. Thank you for listening to me. Now I will pass on the baton to my colleague Avanti, who will start with her slide. Over to you, Avanti.
Hi everyone, I'm Avanti. I'm a counsel at IFF. I'll be highlighting IFF's litigation regarding our challenge to the Criminal Procedure Identification Act 2022, or the CPIA in short. First, I'll briefly go over what this act actually does. So, this act significantly expands the powers of law enforcement agencies to take measurements of convicts and quote unquote other persons for identification and investigation in criminal matters. Here, it is important to understand what the term measurement actually constitutes. So, it includes personal data such as fingerprints, palm prints, footprints, iris and retina scans, signatures, handwriting, etc. So the CPIA also allows for the retention of this sensitive personal data for a very long period of 75 years, and it also allows the sharing of this information between law enforcement agencies. So overall, the act raises very significant privacy concerns and does not really provide for any procedural safeguards. So this is why this was an important statute for us to challenge, and IFF first challenged the constitutionality of the act along with its rules before the Supreme Court in 2022, which was in collaboration with the Criminal Justice and Police Accountability Project. Unfortunately, that challenge was dismissed by the Supreme Court, and we were directed to approach the relevant High Court instead. So now, coming to what we have done right now, that's exactly what we have done. This time, we have approached the Delhi High Court with two students as petitioners who were directly impacted by the CPIA. So the petitioners are two students who had participated in a peaceful protest that was held on their campus at Jamia. And after their participation in this protest, they were issued letters of suspension, and then they were subject. The first petition, one of the petitioners was subjected to also a first information report was basically registered against one person, and after that, the petitioners were subjected to interrogation, and then during after that they were coerced into providing their biometrics, which included fingerprints and photographs. So it's important here to understand that the first petitioner's biometrics were collected even though there was no FIR registered against him, which is basically the first necessary step that sets the criminal justice process in motion. So, given these circumstances, we filed a writ petition before the Delhi High Court challenging both the actions of the police officers in collecting the biometrics of the petitioners, as well as challenging the underlying law itself, that is the CPIA, along with its rules. Now, I'll briefly go over the broad grounds of our challenge, which are as follows: that first, actions, first that the actions challenged by the writ petition are beyond the purview of the CPIA. Second, that the CPIA permits very wide and disproportionate collection of extremely sensitive personal data, which is a violation of Articles 14, 19, and 21 of the Constitution of India. Third, that the CPIA violates the right to privacy, which is protected under Articles 14, 19, and 21 as well, by enabling the storage, retention, and sharing of this sensitive personal data without any safeguards. And fourth, that the CPIA and CPIA rules together violate the right of the accused persons to a fair investigative process. So we've approached the court, and what is happening now is that on 25th February, a division bench of the Delhi High Court issued notice in the writ petition and tagged it along with a pre-existing writ called Harshit Goel versus the Union of India, which had only challenged the CPIA. And the matter is next listed for hearing on 1st of July of 2026. And you can follow updates about the case on our blog and on our Twitter account as well. That's it from me. I'll hand it over now to our Policy Counsel, Janvi, who will share updates about our policy work.
Thank you very much, Avanti. Hello, everyone. Thank you so much for joining. I'm Janvi Annam. I'm a lawyer and I contribute at IFF as a policy counsel. Over this quarter, our policy engagement took multiple forms, such as timely blogs, detailed reports, quick initial statements on current issues, engagement with international human rights processes, RTI advocacies, representations to concerned authorities in order to ensure that our concerns are heard, and many more. I will take a short amount of time and take you through a few key outputs that emanated from such form of policy engagement. Next slide, please. The first is our analysis on Delhi's Safe City project. We observed that this project allowed for AI-enabled cameras to have the capacity to track and process large volumes of sensitive data, including facial images, movement patterns, and behavioral trackers in real time. However, with limited clarity on legal safeguards over oversight mechanisms, we further examined this. We raised questions through an RTI application to bring further clarity. The second, next slide please. The second is Chennai's proposed Citizen 360-degree platform. This platform has also been established within the city's Safe City project. We observed that the platform aimed to unify all citizen interactions into one single system. However, in doing so, it risks creating detailed digital profiles of citizens and individuals by linking distinct interactions with state machinery. Our analysis highlighted concerns around data aggregation. Therefore, we examined the issue through sending a letter of representation alongside our RTI application to concerned authorities. We are awaiting responses on both. Uh, Next, we also sent a submission before Meta's oversight board with regards to a case involving an AI generated sexualized and non consensual video not being taken down despite reporting to the platform. In our submission, we argued that the oversight board should consider such non consensual content to be recognized within their policy and recognize it as a violation of that very policy. I should mention that all of the work conducted by the policy vertical could not have had been possible without the support of all the team members at IFF, including litigation and comms team as well. Thank you very much. Now I'll pass on to the next person.
Thanks, Janvi. Hi, everyone. I'm Advik. I am a comic artist and I handle visual communications at IFF. I primarily use comics as a way to translate complex policy and right based issues into formats that are immediate and accessible. A lot of the themes that we engage at IFF, such as digital rights, censorship, surveillance, freedom of expression, are often a little dense. Comic help bridge that gap. They allow to distill complex ideas into clear visual narratives without oversimplifying the core issue. At the same time, they create an emotional entry point through humor or irony, which makes the content more memorable. Over the last 3 months, our public engagement has grown significantly. In the last 3 months alone, on Instagram, we have averaged over 1 million views per month and welcomed nearly 10,000 new followers. On Twitter, our work has reached approximately 4.5 lakh people. And across all formats, our objective remains consistent. That is to make important issues more accessible, more engaging, and hard to ignore. Now, I will pass it over to Katyani. Thank you.
Hi guys. So I'm Katyaini. You might have seen me on like our Insta page, and yeah. So IFF has really focused on basically establishing a video vertical and like working around video, which like we've not been doing the way we've been doing now. And so like to have like a consistent sort of like video posting schedule and all, we've also gotten in like a full-time video editor, which is like Rini, like they're sitting here and like managing the technical side of things. And we're also like actively collaborating with like other creators who talk about like the issues that like IFF does. And basically because the Instagram and all of this is so video first these days, that like yeah, so we've been like working on the video side of things. Yes, thank you. Abba, you're mute.
Okay, so uh, now I would like to take you through the finances. I'm sorry, I was on mute earlier. And just would like to firstly extend a large amount of gratitude to the people who fund our work, who on month to month basis give us donations which range from 100 rupees to sometimes 2000 rupees to a few, not many, who sometimes even give us 10 to 15,000 rupees. It all adds up. Every single rupee adds up. And unfortunately, it does fall short. So if we can come to the next slide, I'll just like to give you a snapshot of the first 3 months in terms of fundraising. So if you see, there's a spreadsheet here, screenshot of a spreadsheet here of January, February, and March. And the first column has one-time donors, people who don't have mandates with us, just donate to us every now and then. And that has a lot of people as well. And members are those, many of you who have joined this call. who have set up standing mandates with us. And the org donation was the UNESCO uh, Global Media Defense Fund grant, which has lapsed now. It's not been renewed, through which we got about 3 lakh rupees. And on the expense side also, we have some contractor payments, salaries, stipends, rent, operating costs. So it's a granular breakdown of month to month. We also try to provide a snapshot of this in our monthly newsletter. So sign up on that, and that's on Substack. And just when we juxtapose the income and the expense side, we have a shortfall of about 8 lakhs and 52,000 and 874 rupees and 58 paisa. So I'll just like to also talk a little bit about how this funding gap comes out and where do we need our support, your support, and also for those who already do support us, why do we need you to continue supporting us? So if we can have the next slide. So if you add up all the 3 months, the total income was 11 lakhs 58,800 rupees. And again, the one-time donations, people who donate to us occasionally, the member contributions, which are very key, very important, the mandates which are there, ranging from 100 rupees to 2,000 rupees, perhaps even larger, and the institutional and other donations. By the way, one fun insight is that the average amount of money a person signs up to contribute to IFF is about 500 to 600 rupees as a member. So it's not that we have a very large number of people uh, who give large amounts of money. We have possibly a modest size of people who give us a modest amount of money. And in expenses, as you can see, most of the money goes towards contractor payments. And by contractor payments, I basically mean the bulk of our legal and policy team, which is retained and compensated for their time, for their work. And then, of course, we have some salaries, stipends, rent, and operating costs. But as you see, it's not a whole lot. In fact, the rent for 3 months is 58,500. So if you can come to the next slide. And here's the ask. A lot of the work which we are doing is long-term work, and we are one of the few organizations in India which does conduct this kind of work. And we hope to also launch a fundraiser, annual membership drive a little later, because IFF is not being funded by large philanthropies or grants or endowments. We are primarily funded by ordinary people, and that's been our history. So we do have a deficit in the first 3 months. It forces us to reach back into our corpus, threatens the sustainability of the organization. So to sustain ongoing cases, to continue producing independence rights focused research, and to expand public support systems, we encourage you to donate to us. If you have questions, again, you can put it in the YouTube comment section. And if you have questions and comments for us after this call is posted on YouTube and you're watching it there, you can send us questions. You can also reach out to me and you can send me an email. With that, I'd like to now come to the last slide and end this call. So the fight continues because it has to, and with your support, it will. So thank you so much. And a big thank you to all my colleagues and the larger community of volunteers who also work with us. Quite often, they are the ones who are helping us do things technically or appearing for us in courts, such as senior counsel. We all consider them a part of our digital rights community. I'll just uh, now close this call, and I thank you. We'll have more member calls. Possibly we'll notify you the date well in advance next time. Thank you so much for joining.